Property disclosures, the real estate professional's guide to reducing risk. Page 28, Chapter 3 continued. Housing for the elderly or persons with disabilities, unless any child younger than 6 years of age is expected to reside there. Leases for less than 100 days, where no lease renewal or extension can occur. Sales of target housing at foreclosure. Rental housing that has been certified as lead-free by federally certified or accredited inspectors. Lease renewals where disclosure was given and no new information is available. Essential requirements of sellers/lessors. Prior to ratification of a contract to lease or purchase target housing, sellers and lessors must give buyers and renters the pamphlet "Protect Your Family from Lead in Your Home," shown below in Figure 3.1. Sellers and lessors must disclose known lead-based paint and lead-based paint hazards and provide available reports to buyers and or renters. Sellers must permit purchasers a 10-day opportunity to conduct a lead-based paint inspection or risk assessment at their own expense. The parties have flexibility to negotiate key terms of the evaluation. Sales contracts and leasing agreements must include certain notification and disclosure language, including a lead warning statement. Sellers, lessors, and real estate agents share responsibility for ensuring compliance. Records must be kept for 3 years. Buyers must acknowledge receipt of the HUD/EPA pamphlet and the required disclosure regarding the presence of lead-based paint in the housing and the 10-day opportunity to conduct a risk assessment or inspection for the presence of lead-based paint. The listing agreement should contain a provision detailing lead-based paint disclosure and information requirements. Figure 3.1, Lead Safety Pamphlet. Protect your family from lead in your home. Note: lead-based paint that is in good condition is usually not a hazard because when properly maintained and managed, lead-based paint poses little risk. Page 29, Sample Contract Contingency. This contract is contingent upon a risk assessment or inspection of the property for the presence of lead-based paint and/or lead-based paint hazards at the purchaser's expense until 9 p.m. on the 10th calendar day. After ratification, insert date 10 days after contract ratification, or a date is not necessarily or mutually agreed upon. Intact lead-based paint that is in good condition is not necessarily a hazard. See the EPA pamphlet, Protect Your Family from Lead in Your Home, for more information. This contingency will terminate at the above predetermined deadline unless the purchaser or purchaser's agent delivers to the seller or seller's agent a written contract addendum listing the specific existing deficiencies and corrections needed, together with a copy of the inspection and/or risk assessment report. The seller may, at the seller's option, within blank days after delivery of the addendum, elect in writing whether to correct the conditions prior to settlement. If the seller will correct the condition, the seller shall furnish the purchaser with certification from a risk assessor or inspector demonstrating that the condition has been remedied before the date of the settlement. If the seller does not elect to make the repairs, or if the seller makes a counteroffer, the purchaser shall have blank days to respond to the counteroffer or remove this contingency and take the property in as is condition, or this contract shall become void. The purchaser may remove this contingency at any time without cause. Sample lead-based paint disclosure forms, sample confirmation of receipt of lead pamphlet, and sample lead paint renovation notices are contained on pages 35 through 39 of this chapter. Agent responsibilities. Agents must inform sellers and lessors of their obligations under Title 10 and the HUD/EPA regulations. Moreover, agents must ensure that sellers and lessors have met their duties and obligations, or personally ensure compliance with the requirements. Enforcement. In a private action, any person who knowingly violates Title 10 or the HUD/EPA regulations will be liable to the purchaser or lessee in an amount equal to 3 times the amount of damages incurred by the individual. HUD may impose civil monetary penalties of up to $11,000 for each violation of Title 10, or the final rule. EPA may impose both civil and criminal sanctions pursuant to the Toxic Substance Control Act for each violation. The penalty for each violation is limited to $11,000. A home can be tested in one of two ways, or both: a paint inspection tells you the lead content of every different type of painted surface in your home. It won't tell you whether the paint is a hazard or how you should deal with it. A risk assessment tells you if there are any sources of serious lead exposure, such as peeling paint and lead dust. It also tells you what actions to take to address these hazards.